Hi, I'm Bill Browning, a lawyer from Browning, Meyer & Ball in Columbus, Ohio, former NALA president and an active and longtime NALA member. Litigation is the subject of this short lecture, and it is becoming an increasingly important part of elder law. At one time, litigation was almost unheard of in this area of law, and it is now becoming much more common. If you come to this area of law from a past life as a litigator, whether it be domestic, personal injury, probate litigation, or other similar litigation, you're going to find this to be very comfortable. Unless you come from that type of practice in an earlier life, you're going to find this to be a much more difficult area. It's becoming a more common factor in our practices, in part because of any number of issues. One, state budgets are requiring that more applications get denied. More aggressive Medicaid planning has also resulted in the states cracking down on that planning. The Deficit Reduction Act of 2006, actually of 2005, changes some of the planning options that we put in place. And further, with changes in our demographics, the sheer number of applications is increasing. Litigation requires a very different set of skills than planning. The sort of discussions that you have with clients, the sort of explanations you give to clients are very different than the explanations or discussions you have with judges. While interpersonal skills may be very similar, the judges are going to ask a little bit more probing questions. And the answer that you might give to a client, well, the statute says that, may be challenged by a judge or a panel of judges. So the interpersonal skills are not the same. Litigation skills are wholly independent of the planning skills. The ability to cross-examine a witness, the ability to take the information you've received either from a deposition or from testimony and being able to process that and figure out where there may be variances or if you will, inconsistencies is very different. The ability to maintain a certain demeanor, whether it be appearance of anger, appearance of frustration, or a calmness is something that we usually don't have in the planning area. Finally, the ability to research and write persuasively is typically not something that we have to do in the planning side. So the litigation skill set is entirely different. If you're coming to this area, again, having litigated previously in domestic or, again, personal injury or one of those areas, you're going to find the challenge being the substantive area of law, which we're not going to get into today. That litigation may be a little different than what you're used to, but it is still a litigation type base, where again, you're talking about rules of evidence. Rules of civil procedure aren't quite as tight, but you need to understand the rules of evidence and the rules of civil procedure to some degree. The rules of appellate procedure, again, are not all that difficult. Oftentimes what we're looking at in litigation is oftentimes through the administrative process. So oftentimes you're looking at a Medicaid application that's being denied, or someone who's on Medicaid and their eligibility is being terminated, or you're in a circumstance where a person's been on Medicaid, for example, in a waiver program, and they're changing some of the benefits being given. They may be limiting their hours. Maybe they were getting 20 hours a week and now they're going to cut that back to 14. You're entitled to a hearing process should they do that. And your basic constitutional law training that you received in law school will now become important. Due process is central to this litigation process. It's an administrative process, but due process is important. And it's important in the application process. Does your client receive all the appropriate notices? Does your client receive an indication of what they're expected to deliver? On the flip side of that, you better hope your client's telling the truth. Because again, part of this process is a discovery type process. What may be very elementary, it is still a discovery process. So the application process is important. Where a lot of the due process arguments come up, though, is in the notice side. So for example, if the agency gives you notice that they're going to deny the application, well, they have to tell you why. That's part of due process. They have to tell you that the application is being denied for a specific reason. Perhaps you're over resources. Perhaps there was an improper transfer. But then they also need to cite the code sections. What you see in many states is that code section may be the wrong code section. For example, if there's a trust involved, most states have a separate code section relating to trusts. The agency should cite that code section relating to trusts. They usually don't. They may just cite the code section relating to being, in quotes, over resources. We've had a number of circumstances in our state where the caseworker won't even refer to the correct code. They'll refer to an old manual that used to be the law as opposed to the Ohio Administrative Code, which is now the law. So they'll cite it as Ohio Administrative Code section, for example, 7433. Well, there is no such administrative code section. So again, that notice is defective. And you have a right to challenge that. You have a right to challenge almost any action that they take, including estate recoveries. When you get to your fair hearing, and again, some states are called fair hearings. In Ohio, they're not called fair hearings because they're probably not fair. The process that we look at in each one of these, and again, I've cited the federal code section that typically governs this area. We look at the contents of the notice. You also have to look to who the notice was sent. If you have a power of attorney, if you have a guardian and they filed the application, they're entitled to that notice. For example, if you have a circumstance where a person's in a comatose condition and their guardian or their attorney in fact has filed the application, the agency serving the notice of denial upon the comatose person is probably not good notice. Similarly, if the notice is served upon a minor, it's not good notice. So again, the actual delivery of the notice is important. The timeliness of the notice. The federal code is pretty tight as far as what they're supposed to do. They're supposed to rule upon applications timely. In most states, that's supposed to mean 45 days. In very few states does it happen in 45 days. If you ask for a hearing, you're typically required to ask for a hearing within 90 days of the agency action. If you miss that time period, you're probably out. So again, the timelines are very important on the notice, on the request for hearing, on the date of the hearing. Usually these hearings go back to the date of application as far as the ruling itself, but it makes the process a little bit more nuanced. When you look at these hearings, again, we're going to cover probably 4 different levels here. The first are the fair hearings. The second is the first level of appeal. The third is judicial review of that process. And finally, federal court action, which we won't spend much time on. Again, the fair hearings, again, as set forth in the code section previously cited, are kind of loose. Each state does them a little differently. And there's really 3 basic models that are followed. The first is where you have an administrative law judge who's subject to review. New Jersey is a good example of this. In New Jersey, they have an attorney who's appointed as an administrative law judge. He or she hears the case, and they generally do it. It's not quite as formal as a trial, but it's pretty close. They take in evidence, they take in oral arguments, and they render a decision based upon the facts and the law. In New Jersey, that decision is then subject to review by the director of the state Medicaid agency. So if he doesn't like the decision, he can simply strike it, overrule it, and the eligibility is still denied. But again, you have the benefit in those cases if you have a decision written by a lawyer who's independent of the agency that may side with you, and if you have to appeal further, you really have a good base for appeal. In some states, very few states, you have an administrative law judge with binding decision power. And very similar to New Jersey, it's a real lawyer who's not employed by the agency, who issues a decision, and then either side typically can appeal that through the administrative processes and up to judicial review. The last and most difficult area is where you have what I've generally called a hearing officer. In Ohio and many other states, that hearing officer is not a lawyer, usually. Occasionally they are, but usually they're not a lawyer. They're employed by the same agency who denied the application. They're trained, promoted, demoted by that same agency. In our state, for example, that hearing officer will hear the case, they'll hear the evidence, they'll look at the briefs that are filed, they'll listen to oral arguments, but they aren't even permitted to issue their own decision. They report back to a supervisor who's not present, who then actually issues the decision. This is the weakest of the hearing type processes you go through. But they are still important, whichever one of these processes you have to go through. If you don't put on a good case, you don't really have much to appeal on. So for example, in any of these, you need to put on a good record, whether that record consists of affidavits or testimony or cross-examination. You must get your facts in. And again, if you don't get facts in at this hearing level, at this fair hearing level, you cannot generally supplement the record at a later date. Now, you can sometimes ask the hearing officer to keep the record open for 10 or 20 days, but typically, once you've gone through that hearing, the record is closed. You must also raise your legal arguments during this fair hearing. If you don't raise the legal arguments, there's a pretty good chance your arguments are waived. So if you have a deficient notice and you don't bring that up during the fair hearing, you can't later bring it up at your judicial review level. So again, this is a little bit like your trial, and you have to treat it like a trial. Your cross-examination is typically going to be of the caseworker or caseworker supervisor. In some states, you may have opposing counsel at the table. You may not. Again, you need to kind of become familiar with your state processes as far as how they do these fair hearings. Anytime you want to appeal a change, a denial, or a termination, generally you must start with this fair hearing. There are some circumstances you can go directly to federal court, but that is not common. Your request for hearing is fairly simple. Usually with the denial form or the termination form, there's a place on there to request a fair hearing. You have your client sign that, or you sign on behalf of your client, you send it in, and usually within 60 to 90 days, you'll have a hearing scheduled. In some states, those hearings turn pretty quickly. So when you send that in, you better be ready, because you may end up in a hearing within 10 days. Typically, there's no discovery. Typically, you're not permitted to go down and depose the caseworker in advance. You are permitted to see the case file in advance. You should see the appeal summary in advance. If you don't receive the appeal summary, you should object to the appeal summary being introduced. I think you're getting the flavor of real litigation. It's not something you can go in and just wing it. In most circumstances where you have a termination process that's ongoing, when you ask for the fair hearing, if you ask for it timely, and usually within 10 days of the denial, 10 days of the termination, typically services are continued while that litigation is pending through the administrative process. They can terminate those services usually once you get into the judicial review. But in a termination case, you want to make your request for fair hearing nearly immediately. The conduct of the hearing, it depends a lot on the state. Again, some states treat these very much as like a trial, and you're permitted to present witnesses, you're permitted to present evidence, you're permitted to get subpoenas. In other states, such as Ohio, while the code provides for the issuance of a subpoena, we've requested probably 70 subpoenas over the past 20 years and never had one issued. They simply do not follow the law. You can, however, introduce evidence. Typically, the process in some states, most states, I would say, is a little less formal than a regular trial. They'll let you get some hearsay in. They will allow you to introduce evidence from third parties, again, by way of subpoenas, by way of court orders, without the usual process you'd have to go through in a regular trial process. But again, you have to do the research well enough to know what sort of process your state has. Again, if you have an administrative law judge, he's usually going to be a little bit more formalized than a hearing officer in a state where it's not even a lawyer. Obviously, most hearing officers who aren't lawyers don't understand the rules of evidence or civil procedure anyways. So the conduct and the scope of the hearing, typically you're allowed to ask any questions you'd like. So, for example, one thing that we usually try to do is in circumstances where a caseworker is known for being repeatedly late in processing applications, we'll ask the question, how many applications do you have that are over 90 days old? In a state where you have an administrative law judge, they'll probably allow that question in the record. Where you have a hearing officer who's employed by the agency, they typically don't favor that sort of questioning and typically will restrict you or attempt to restrict you. However, the federal law says that you're permitted to ask your questions, present your case in an unfettered fashion. I always like to comment that when the hearing officer restricts me, that I'm feeling fettered. What happens when you lose the fair hearing? And again, in those states where you have a hearing officer and not an administrative law judge, if there's much by way of controversy, you're probably going to lose, no matter how good a job you do. Again, in some states, your appeal is just to the director. Again, particularly where you have an administrative law judge. In other states, you may have a panel, and typically that panel in those states is usually made up of lawyers. But again, you must have a good record at the fair hearing. You must, again, restate your legal arguments. And I would typically restate my facts so that they're clear to the administrative panel. If the hearing officer has made an obvious error, you've got a reasonably good chance that the administrative appeal panel will rule in your favor. Again, you cannot produce additional evidence, and typically you can't produce additional arguments. So if you didn't present the legal arguments at the lower level, it's hard to shoehorn those in here. Again, in some circumstances, you may feel like these cases these arguments and these the sort of process is a rubber stamp, and it may well be. Judicial review. Now you're in the big leagues. You've got a real judge. He's either elected or appointed by the governor or some panel. He's not answerable to the director of the department to the Medicaid agency. That's a good thing. This is maybe your first chance to really have an unbiased hearing officer or hearing authority, particularly in states like Ohio. Again, your record is what you've done below. So that may be your fair hearing, your administrative appeal, your briefs, your affidavits. That's your record. In some circumstances, you can actually get a transcript of the fair hearing in. In those circumstances where we've had an effective cross-examination and the caseworker has made admissions verbally during the testimony, I'll oftentimes want a transcript introduced into the record. I can't introduce new evidence at the first level of judicial review. The evidence has already been ascertained. Further, again, legal arguments. Typically, you've already made these. Typically, we put those in a written form in a brief, so that way we can clearly show that we've raised the issue. You don't necessarily need to give 40 pages of case law on bad notice. You must simply raise at the fair hearing that there was bad notice, indicate what the substance of the bad notice was. Again, citing the wrong code section, sending it to the wrong person. You don't need to go into the case law at the fair hearing, but you needed to raise the issue. Typically, in most states, once you get to this level, the court will treat this as an administrative appeal, much like you would have on a zoning case, or much the same as you would have on an appeal on a licensing case for a doctor or a dentist. So it's a very similar process. And typically, you have a fair amount of case law in most states. You need to review that case law prior to pursuing one of these. The process typically involves perhaps a status conference, a briefing schedule. You may end up with some motions. We've noticed that we've had a number of motions relating to we've wanted to introduce a transcript. The hearing, the state may oppose that motion for a transcript. We've asked other circumstances where evidence that they refused to admit at the fair hearing be admitted at the trial court. But again, we attempted to raise those arguments at the fair hearing, so it's not new. That sort of motion practice is part of this. Once you work your way through that, then the court's going to ask for briefs on the substantive issues. They may or may not allow you to do oral arguments. Keep in mind that in most states, the judge at this level is a trial court judge. He's usually hearing murder cases, big civil trials. This is not high on his priority list. But it's also not one that requires a huge amount of his time. The other thing you run into, and again, depending upon your state, in some states you're going to see an attorney at the fair hearing. Typically that will be someone from the Attorney General's office. It could be somebody from the county prosecutor's office. Whenever you get to the level of judicial review, when you're in the courts, you're going to have an assistant attorney general appointed. You may well have a special attorney, basically who's appointed, who's in private practice, but one way or the other, you're going to have an attorney on the other side. And I will tell you, in my experience, the opposition has improved significantly over the last 20 years. We typically, and the more difficult these cases, the more likely we are to ask for oral arguments at the trial court level. This judge is typically not familiar with the Medicaid program, and these rules have been described as unintelligible to the uninitiated by a judge, I believe it was in New York. So sometimes the judges actually can benefit from oral arguments. We've had oral arguments done sitting in the chairs in the judge's office. We've had them done in a regular courtroom. Whatever the judge feels is appropriate is the way you would proceed with that. Federal court actions are uncommon. You have to have some sort of federal issue. And the federal court litigation, the federal courts tend to be a little bit more rule-bound. Federal judges are typically appointed and are not removed, they're not elected. So it's one of those things that you have a judge who can pretty well run his courtroom any way he wants. If you start filing actions in federal court, you're going to hear about things like the Rooker-Feldman doctrine and the Younger abstention doctrine. And if you don't know what those things are, you probably need to get some help as far as filing a federal court action, because you're going to see those defenses raised by the state. Anything they can do to disrupt a federal court case, they will do. So I'm not going to spend any more time on federal court actions. Special needs trust. With the population of special needs children increasing, both autism and Down syndrome, the proliferation of special needs trusts is not mind-boggling, but it's very significant. And what you're starting to see is some states, as they run short of funds for their Medicaid program, are starting to look at these special needs trusts a little harder. Ohio is one of the states, along with Oklahoma and again New Jersey, who have always been a little hard on special needs trusts, but it's starting to spread through other states. And typically what they're doing is one of two things. They're either looking at the trust itself and saying, based upon the terms of this trust, it should be a countable asset, or they're taking a policy swing at it with the effort of essentially creating case law to defeat special needs trusts in general. Now, I don't want to get into the substantive area of special needs trusts, but typically you have some litigation strategies you need to pursue. These may occur when you're applying for Medicaid. They may occur when someone who's already eligible has a family member die or create a trust for their benefit. One of the first things we look at is the quality of the trust document. If the trust is pretty close to what our state code permits, then we're more likely to go a different direction than if it varies significantly. For example, I litigated a trust case recently where the trust was done in 1991, and the woman died at that time, but her child, we didn't even ask for benefits until 2004. Statutes changed several times in between her death and the date of the Medicaid application. So her attorney would have found it almost impossible to draft a trust that would be consistent with the statutes passed 12 or 13 years later. So you have to look at your venue. Where are you going to file? Are you going to file an action appealing a denial or appealing a termination and go through the fair hearing process? Or are you going to go through some sort of court process and try to skip the administrative process? I would suggest in those states where you have non-lawyers acting as hearing officers, try to go to court. The quality of the decision will be better. The court may actually understand what a trust is. They may have actually read one or two trusts during their lifetimes. Whereas if you go into the fair hearing process and you have non-lawyers issuing decisions, the quality of the decision will be very low. So that's your first decision, is do we go directly to court or do we go through an administrative process? Then your strategies change somewhat when you get to that next level, depending upon the quality of the trust. If the trust is really right on the point as far as the code sections that you have to look at in your state, you may simply ask for a declaratory judgment. Whereas if it varies a little bit, you may either have to ask for a reformation or you may plead in the alternative for a reformation. Again, this is a fairly nuanced area, and the trust itself is vital to the case, but depending upon how aggressive your state is, you need to adjust your strategies. These are going to be more prevalent over the next 10 or 15 years than they have been in the past, and I think you're going to see it probably throughout the country. A lot of this also depends on whether or not your state has adopted the Uniform Trust Code. And you'll see sections in the Uniform Trust Code relating to reformations and declaratory judgments. Also depends on how aggressive your state wants to be. You may be surprised how willing they are to take money away from disabled kids. The last subject I'm going to hit briefly is estate recoveries and liens. Again, it's a substantive area of law that's different from administrative hearings, it's different from straight Medicaid, it's different from special needs trust. It's a product of statutory law. And back in 1993, OBRA included a section that required that states start pursuing estate recoveries. And the states, some have moved this very aggressively, some have moved very slowly. West Virginia, for example, typically does not even really pursue estate recoveries. They have a manual that their Attorney General put out that basically says, here's how you avoid estate recoveries. Most states, however, are moving towards a position where they're trying to recycle or recover those dollars spent. Typically, in most states, their code either provides that they can pursue only probate assets, while some go beyond the regular probate code, and they can pursue an augmented estate. You have to know what your state law is. You have to really pay a lot of attention to their procedures. Did they, for example, give good notice to the applicant when the applicant applied for Medicaid? Typically they should. Are they trying to recover from the applicant's estate? Is there a spouse? Is there a minor child? Is there a disabled child? All of those specific factual items play into the process. Where do you litigate these? Typically, you can litigate these either in the probate court or your general division or through an administrative process. We have generally avoided the administrative processes in our state because that's not what our code provides. But typically what you would do on the estate recovery is you go through the usual process that you would go through with any creditor. Number one, does your executor have to give any sort of notice to the state that there may be an estate recovery? Number two, do they have to file a claim within a certain number of days, weeks, or months? Number three, if they file the claim, what's your process for forcing that to a resolution? Usually there's a rejection statute in your state that you must look at. And then where does the case get litigated? Typically, again, one court or another has jurisdiction over those processes. In some states, the Attorney General's office does those recoveries. In other states, they hire special counsel, essentially collection lawyers, to do those recoveries. But again, it's a whole another separate area of litigation that you must get into, and you must be comfortable with the process first and foremost. Even if you understand the substantive law, the process may not be something you've experienced before. I know most of the probate lawyers that I work with are not familiar and are not that comfortable with rejecting claims and going through the litigation process in our state. So it's another area that we'll be looking at. In summary, when you're litigating in the Medicaid world, you've got certain issues. You've got all of your notice and your constitutional issues. And they typically, again, revolve around notice and due process. You have your defense issues, and your defense really is usually mounted somewhat in mistakes that the agency may have made either at the time of application, at the time of denial, but you have to really mount your defense. And again, think about a strategy or on the procedural side as far as, how do we find the technicalities they might have missed. And finally, you've got your substantive arguments, and those substantive arguments are usually based upon your code within your state. Again, depending upon what sort of litigation you're involved in. This sort of work is going to be such that we're going to look at, I think, an increased amount of litigation over the next 20 years. And if you don't feel comfortable doing litigation, you need to work with a litigator who is comfortable doing that litigation. At Browning, Meyer & Ball, my partner, Richard Meyer, at one time was a domestic litigator, so we have a comfort level. I've litigated at the appellate level quite regularly, so we have a comfort level with this. If you don't have that, align yourself with someone who does. Thank you.